This is not getting discussed on the mainstream media. Not only are they wrong legally, but the fact that they would do this is outrageous. This is an overreaction and really nonsense. How would you react if this was your son or your daughter? It's the offense of knowing the truth. It's the offense of having an alternate worldview. Saying God bless you to someone is not a violation of the law.
Welcome to the broadcast, everyone. This is going to be a unique program. We're going to actually take you inside a hearing room on Capitol Hill. The issue before Congress is the ongoing scandal involving the IRS and now the Department of Justice involvement. Let's take a look.
On behalf of the American Center for Law and Justice, thank you for allowing me to participate today. I serve as counsel to 41 organizations that have filed federal litigation against the IRS and related officials regarding the targeting. We were in cooperation with the Department of Justice for a period of time with their investigation. But when I chronicle the order in which things have developed over the last several months, specifically the missing emails, which is key evidence in this case, the faux apology that Lois Lerner gave when this scandal broke over a year ago, I have unfortunately had to conclude that the investigation by the Department of Justice is also a faux investigation. It is at surfaced at best, and we were compelled to in a situation where we were producing clients for these investigators, for DOJ officials, for FBI agents, for Ms. Bosterman, to interview, with the assurance from the FBI that our clients were not and have not been subject to criminal investigations and were not targets of those investigations. They made that clear. Then an email surfaced in a batch of emails that were delivered. This one was dated May 8th of 2013. Of course, it just came out several weeks ago. It is from Lois Lerner. It is to Nicole Flack, who was the Chief of Staff for the then Commissioner of Internal Revenue Service. I got a call today from Richard Pelger, Director of Elections Crimes Branch at DOJ. I know him from contacts from my days there. He wanted to know who at the IRS, the DOJ folks, could talk to about Senator Whitehouse' idea that a hearing that DOJ could piece together false claim cases about applicants who, quote, lied, end quote, this is her email, on their 1024s, saying they weren't planning on doing political activity and then turning around and making large, visible political expenditures. DOJ is feeling like it needs to do something to respond, but they want to talk to the right folks at the IRS to see whether there are impediments from our side and what, if any, damage this might do to the IRS programs. I told them we need to talk to several folks at IRS. I'm out of town all of next week, so wanted to reach out and see who you think might be right for such a meeting. All hands on this. All hands off. I'll hand this off to Nan as a contact person if things need to happen while I'm gone. Piece together false claim cases so that my clients, with, by the way, and acknowledge, no evidence, could be subject to what? Grand jury investigations? And at the very same time, this comes, by the way, out 2 days before the apology from Lois Lerner. So this was an ongoing, systematic scheme. And Ranking Member Conyers, with due respect, there were a couple of liberal groups that were picked up in this dragnet. None of them were denied their tax-exempt status. I've got one client, by the way, that has been held for 5 years. Still does not have that status resolved. So we've got an email saying, let's piece together or attempt to piece together false statement cases. Another email, March 27th, just a few months before. This one again, Lois Lerner. As I mentioned yesterday, there are several groups of folks from the FEC world that are pushing tax fraud prosecution for C4s who report they are not conducting political activity when they are, or at least these folks think they are. One is my ex-boss, Larry Noble, former general counsel at the FEC, who is now president of Americans for Campaign Reform. This is their latest push to shut these down. One IRS prosecution would make an impact and they wouldn't feel so comfortable doing this stuff. By the way, the stuff they're talking about is activity protected by the First Amendment. So I've got an email from the IRS referencing a Department of Justice call while the Department of Justice is supposed to be conducting this investigation. We know that there's the missing emails, but what may not be known is that there was actually a much earlier FOIA request. This has not been discussed publicly. This FOIA request was made in May 27th of 2010, right when this whole issue started just getting some attention. It came in from Lynn Walsh. She did this as an independent journalist. She sent it to the Internal Revenue Service Disclosure Office, asking for, as she phrased it, documents relating to any training, memos, letters, policies, etc., that detail how the tax-exempt government entities division reviews application for nonprofits, 501c3s, and other not-for-profit organizations, specifically mentioning Tea Party, the Tea Party, Tea Party, or Tea Parties. The response that came into this request, of course, took until January 6, 2011. It's a quick response. We found no document specifically responsive to your request. Well, we know that's absolutely false, because there's been, even the ones that are, take out the ones that are missing, there are literally thousands, tens of thousands that were responsive to this. This is the cavalier attitude upon which the IRS was conducting itself. That's problematic. This is an office I served in. My first job out of law school 250 years ago was Chief Counsel's Office of the IRS. I have a lot of respect for the office. I served on the legal faculty for the Department of Justice. This isn't something this unpleasant about this. This is damaging, it's troubling, and Mr. Chairman, in all due respect, that could be solved so easily by appointing a special counsel to get to the bottom of what is clearly a significant problem, the last of which is the missing emails. Thank you.
It is absolutely critical that we get real answers to this situation. The IRS targeted citizens because of their religious views, because of their political views. That's wrong, it's illegal, in fact, it's a crime. But we now need a special counsel to investigate this because the Department of Justice is involved in the activity itself. So here's what we are asking you to do. Join with us in a petition to appoint a special counsel, a special prosecutor, to look at this IRS matter in detail. You can add your name to that petition at aclj.org or simply call us at 1-877-989-2255. That's aclj.org or 1-877-989-2255. We must get answers. We need a special counsel. We need to have that happen today. Again, aclj.org or 1-877-989-2255 to get your name on this petition to get justice.
The investigation into the unlawful IRS targeting scheme, now more than ever, requires a special prosecutor to get to the truth. In recent days, we've learned that the IRS broke the law by giving the FBI more than 1 million confidential taxpayer documents, urging the agency to investigate Tea Party and conservative groups. Now, the IRS wants us to believe that it has lost the emails of former top IRS official Lois Lerner, who's at the heart of the scandal. Yes, the IRS says Lerner's emails from 2009 through 2011, a critical 2-year period, are now missing because of a computer glitch. The IRS stonewalling must end. The American people deserve the truth. And as we continue to pursue our federal lawsuit, it's clear that a special prosecutor must be appointed to get to the bottom of this troubling scandal. Add your name now to a new ACLJ petition. Call 1-877-989-2255 or add your name online, aclj.org.
Welcome back to the broadcast, everyone. We've taken you inside the hearing room. You heard my opening statement. Now the questions come from members of Congress. Again, as we get ready to go to this particular portion of the hearing, let me encourage you to take a stand here against what the IRS is doing, and let's get a special counsel appointed to get to the bottom of this unbelievable scandal that's impacting the IRS and now the Department of Justice. Again, you could add your name at aclj.org or 877-989-2255. Now let's go to the hearing.
Let me thank you. Mr. Sekulow, are you, if I'm sorry, get me, have pronounced your...
Sekulow.
Thank you so very much. Are you here testifying that the AG must appoint a special counsel?
Now, we clearly have stated in my written testimony and our testimony that it's discretionary. What we're asking is that the Attorney General utilize that discretion to appoint a special prosecutor.
And your reasoning is?
That the Department of Justice has been compromised in the investigation, particularly because they were in coordination with the IRS in manufacturing, as they said, piecing together criminal cases against clients like mine. And that in and of itself raises a significant conflict. In fact, puts the whole investigation in a taint, because the Department of Justice is investigating itself for potentially involving themselves in violation of criminal laws. And I'd just like to add to the record that it was the Attorney General of the United States, and it may have been in this very room, who was the one who brought up the code sections, 242, of the criminal code that could well have been violated if, in fact, the evidence showed it. And now we've got the email saying his Department of Justice.
Thank you. Mr. Gotti, I was asked a little generous time here, and Mr. Gotti would just allow me to ask Mr.
You
Teifer.
mean in addition to the 53 seconds already allotted, more additional time?
Your kindness, Mr. Chairman, so I can have Mr. Teifer respond to that very quickly, and I would appreciate your indulgence. Mr. Teifer, if an investigation by the DOJ is not yet finished, can we see the point that there is conflict and that they're not fully investigating as professional staff members of the DOJ? Can we make that judgment? I think we cannot. What is your assessment?
Professor, you may answer the question with all deliberate speed.
I thank you. So to avoid the $80 million that's been spent on special counsels. Thank you, Mr. Chairman.
There's an investigation going on. We can't decide they're not doing a good job because they're doing a good job.
I thank the gentlelady.
Thank you. I yield back.
Thank the gentlelady from Texas, and now recognize the gentleman from Arizona, Mr. Franks.
Well, thank you, Mr. Chairman. Mr. Sekulow, a lot of the questions that we've had here prepared, some other person on the committee has stolen. I'm thinking about filing some sort of deliberate inquiry as to how that always happens to me. So I'm going to, if I can, just back up and take a broad look at this. You know, we've heard the central talking point of our friends on the left here is that this is the last full day before the break, that we shouldn't be dealing with such a minuscule issue. And I would just suggest to you that I think the issue that we deal with here is one of profound significance, in that the entire basis of a government that is essentially predicated on the rule of law is that somehow we can trust our government to treat us all equal under the law. And I think that's the central point here. And if indeed the IRS is guilty of using the power of the federal government to discriminate against people on the basis of political motivation, then the entire rule of law here is at stake. And this committee, being the Judiciary Committee, should be first and foremost committed to protecting the constitutional rights of the American citizens and to do everything that we can to further this notion of the rule of law. So I think it's a really big issue here that we're dealing with, and I guess I'm going to ask you to put it in your own words. Why do you think this is such a big deal?
Because fundamentally, when you look at the tax code as it exists, it's a voluntary compliance. The idea that that if a conflict were to arise during the course of an investigation, that you have to wait for the investigation to be completed is absurd. If the rule of law means anything, and with due respect to the Congresswoman, if the rule of law means anything, when you've got an agency with this amount of authority, both the Department of Justice and the IRS, and there is evidence in writing, not denied, that there was activity going on between two agencies while there is a criminal investigation going, if the rule of law means anything, if that conflict becomes known, it should be actionable. Now, that action rests with the Attorney General. But to say that we shouldn't be able to bring it up or discuss it or that it's not as significant of these other issues that the Congress is dealing with right now, I beg to differ. The freedom of speech, the freedom of press, the freedom of assembly, the freedom to petition your government for redress of a grievance is at the very core of who we are. And when that is tampered by two agencies, and one in particular that controls the lives of every American citizen, I don't think it's insignificant that this work is going on today. No disrespect to any other piece of legislation you're dealing with, but this is a very significant burden placed on American people for simply exercising their free speech rights. And when an agency has violated that trust and there is notification that in fact there is a conflict, you do not have to wait for the investigation to be completed because you want to talk about a waste of money? Know about a conflict, don't react on that conflict. In the law, if you do that, it's malpractice. And you know what ends up happening? You got to do the investigation all over again, and Congresswoman, that becomes a lot more expensive.
Well, obviously, I couldn't agree with you more. I would suggest to you that we're in violent agreement on that subject. You know, the notion that we all pay our taxes voluntarily, there is something that you brought up in your response. It seems to me that if people believe that the IRS will arbitrarily begin to persecute particular groups, that people begin to wonder, why do we even pay taxes? And the entire process, the entire hope of our government is based on a fundamental, intrinsic trust of the American people that somehow that this thing called law is going to prevail, that everybody's going to be treated fairly under it. And if it isn't, then it's time for us to go ahead and give our apology to England for being so recalcitrant in the revolutionary days, and to board this place up and go home and wait for the end patiently. So this is not a small issue that my friends on the left would try to suggest. So my last question to you, Mr. Sekulow, is this. What do you think is the most significant? I know we've got, the conflict of interest. I know we've got the president saying that there's not a smidgen of corruption here. All of those things bear thought. But what do you think, in your opinion, is the most significant legal or glaring piece of evidence that shows that the IRS has deliberately used its power in an untoward, in an unfair, and outside the rule of law?
Besides their own admission, Congressman, of
that's a detail.
That's right.
Yeah.
If you look at the email exchange from Lois Lerner to other officials within the IRS referencing her conversation with the head of the director of the Election Crimes Branch of the Department of Justice, and uses the words "piece together false statement cases" to see if they, quote, lied, to impanel a grand jury, that would be the next thing. And of course, no evidence of any criminal wrongdoing here. That is a government that is out of control, out of check, and needs to be put back in balance. And that's why a special counsel would be a good move, not mandated, but a good move for the Department of Justice to make here. They themselves are part of the problem. It's in emails right here.
Well, you just heard the major issue that started developing was an email that came out that had the Department of Justice referenced in it about manufacturing criminal cases against our clients. And you're talking about indictments against people for exercising their First Amendment rights to freedom of speech, freedom of religion. We want to get to the bottom of this, and you're going to hear in the rest of this hearing, we really aggressively push our case forward. But what we need, in addition to our litigation, is a special counsel appointed that's going to really look at this in great detail. We need your help on that. We've got a petition up at aclj.org. I want to urge you to sign it, or call us at 1-877-989-2255. You can sign your name to that petition there again, aclj.org, or 877-989-2255. We've got a lot more from the hearing room when we come back.
The investigation into the unlawful IRS targeting scheme, now more than ever, requires a special prosecutor to get to the truth. In recent days, we've learned that the IRS broke the law by giving the FBI more than 1 million confidential taxpayer documents, urging the agency to investigate Tea Party and conservative groups. Now, the IRS wants us to believe that it has lost the emails of former top IRS official Lois Lerner, who's at the heart of the scandal. Yes, the IRS says Lerner's emails from 2009 through 2011, a critical 2-year period, are now missing because of a computer glitch. The IRS stonewalling must end. The American people deserve the truth. And as we continue to pursue our federal lawsuit, it's clear that a special prosecutor must be appointed to get to the bottom of this troubling scandal. Add your name now to a new ACLJ petition. Call 1-877-989-2255 or add your name online, aclj.org.
Welcome back to the broadcast, everyone. We're going to go back inside that hearing room. One of the issues that came up was this whole discussion about why the ACLJ stopped cooperating, or had our clients stop cooperating with the Department of Justice. And it was because we've got an email that says the Department of Justice was looking to make potential criminal cases against our clients. And for that reason alone, we stopped cooperating. And by the way, the Department of Justice initially told us that our clients were never a target of these investigations. But what happened was that emails, as they come trickling out, more and more information, implementing and really in a very real way, implementing a scheme that included now the Department of Justice, and without a doubt put our clients in a very difficult position. So we simply shut down voluntary cooperation. That came up in the hearing. Let's take a look.
Mr. Sekulow, when the Justice Department first launched its supposed investigation against the IRS, the groups you represent were cooperating with that investigation. However, you explain in your testimony that your clients are no longer cooperating in that investigation. Can you tell us why?
Well, when the emails came out from Lois Lerner that stated, and the one in particular is the one dated May 9th, 2013, which we just received this summer. back in early June. It's the email that says that the call took place between the Director of Election Crimes at DOJ, talked about, quote, piecing together false claim statements about applicants who, quote, lied, end quote, saying they were planning on doing political activity and then turning around not doing it. DOJ feels like they need to respond. Well, we were assured initially that our clients were never the subject to an ongoing criminal investigation. They were just being produced as witness. Then I get this email that says, in fact, they were looking at piecing together evidence in cases against our client, piecing together, no evidence of anything. And by the way, that letter that we sent to J.P. Cooney, the trial attorney at the United States Department of Justice, it was the lawyer that the letter was addressed to, that letter from the ACLJ, which is part of the record, was dated June 18, 2014, and has never been responded to.
It appears that some, even not in the committee, regard all of this with a flippant attitude as no big deal. I agree. This is a constitutional issue. It involves real people. One of those is Catherine Engelbrecht, a friend of mine in Texas, who, because she had the nerve to make sure that the voting booth was sacred and there weren't dead people voting and there wasn't other corruption, starts an organization called True the Vote, and immediately thereafter, here come the government officials. She was audited by the IRS, visited by the FBI terrorist squad. She was audited by the equivalent of EPA in Texas. OSHA investigated her, constantly under the surveillance of the IRS. Questions after questions after questions. It's real people. Her constitutional rights were violated because she was persecuted because she took a stand different than government. The Constitution protects that absolute right for all Americans. And then here's a timetable. I'm sure you have it all memorized. Eric Holder hides information, misleads Congress in 2011. So in June 2012, over 2 years ago, the House, in a bipartisan vote, holds him in contempt. May 2014, the district judge took the DOJ motion for summary judgment under advisement. 2 hearings since then. In July 25th, all the parties met with a mediator, and still no resolution to the Attorney General of the United States being held in contempt. Now, I look at a contempt of Congress similar to an indictment. Would you agree with that, Mr.
The
Sekulow?
repercussions are very serious, yes.
It's an indictment and then tried by the Senate if it ever gets that
Right.
far. We have a situation that is similar to a district attorney down in Texas or Louisiana or Chicago, wherever, pick one, getting indicted by a grand jury for corruption, but yet the DA decides whether or not there will be someone not in his office or her office to prosecute him. Isn't that the same situation we're in?
It is, and that's why the discretion and the better part of discretion here would be for the Attorney General to appoint a special counsel.
No kidding.
Also,
just a
talking
second,
about
Mr.
judges.
Sekulow, I only have 5 minutes.
Please.
I'll let you talk.
No.
Through.
Your floor.
And not only that, you've got the Justice Department, Eric Holder, representing Lois Lerner in court.
That's what I was going to hold up.
Where I come from, you cannot have lawyers for one law firm and the same lawyers on the other law firm representing opposing individuals. It's a violation of ethics. Is that not generally true, Mr. Sekulow?
It is. Their argument is, Congressman, that it's different departments handling it, but and I need
it's
you.
Still the Justice Department.
Of course it is. It's still within the Justice Department.
Just a second. I know you're talking. I'm like Mr. Johnson. I admire your passion.
No, go, please.
But Eric Holder is defended by the Justice Department in the district court here, whether or not to uphold the contempt. So he's in court as a defendant. Taxpayers are paying for his lawyer. I personally think he ought to get his own lawyer. Taxpayers shouldn't pay for his lawyer. He should get his own criminal defense lawyer. And yet they're on the other side as well, or we have private lawyers on the other side trying to get the district judge to make a decision. Doesn't this seem a little bizarre that you got the government representing the accused individuals on one side and the prosecution on the other? My question is, maybe we should step back eventually and pass legislation that the district or circuit court, like in D.C., should have jurisdiction to pick a special prosecutor when it's the Attorney General that is in trouble with Congress. What do you think about that?
I think it's an interesting proposal. You'd have to look at the ramifications and how it would affect the working of the Department of Justice, but you raised the right issue, and that is I'm holding up the lawsuit. So in this particular case, this is our amended complaint, you've got the Department of Justice representing the IRS and all the government officials, also the individuals, and the individuals also have outside counsel, which I believe are being paid for by taxpayer dollars. I'm not 100% sure of that.
And with my analogy, if I may have one more question, with my analogy of the district attorney being indicted for corruption, it's like having the district attorney's office represent the district attorney in court.
Right.
Yet the district attorney has got to pick the prosecutor to prosecute him or her for corruption. That seems a little bizarre.
Lack of incentive to get to the bottom line of the issue. That's the problem, yes.
Here we now recognize a gentleman from Georgia, Mr. Johnson.
Thank you, Dr. Sekulow.
Yes, sir.
Your name will live in infamy as a litigator extraordinaire. Whether or not you agree with your positions or not, you have to tip your hat to a litigator, a man who uses the courts as the courts should be used.
By the way, that statement from Congressman Johnson, a Democrat from Georgia, I think really does sum up the issue, and that is we have to utilize the courts here to get justice. Now, there's two ways to do it. One is going to be through the litigation that we have ongoing right now. The other, of course, would be the appointment of a special counsel. But there you heard a Democrat saying really positive things about the approach we're taking, even though he disagrees with us politically. But there is bipartisan opposition to what the Department of Justice has done here by not appointing a special counsel. So we think now is the time, and this is where you come in. We've got a petition up at aclj.org. We want you to sign it. You sign that petition, you're adding your name, urging the appointment of a special counsel. It's in the discretion of the Attorney General. We want him to exercise his discretion. You can join that petition at aclj.org or 1-877-989-2255. That's aclj.org or 877-989-2255 so we can get a special counsel appointed. We've taken you inside the hearing room here. You're not going to see this on a lot of other places, but now you got a real sense of what goes on. But your help is needed. aclj.org or 877-989-2255.
The investigation into the unlawful IRS targeting scheme, now more than ever, requires a special prosecutor to get to the truth. In recent days, we've learned that the IRS broke the law by giving the FBI more than 1 million confidential taxpayer documents, urging the agency to investigate Tea Party and conservative groups. Now, the IRS wants us to believe that it has lost the emails of former top IRS official Lois Lerner, who's at the heart of the scandal. Yes, the IRS says Lerner's emails from 2009 through 2011, a critical 2-year period, are now missing because of a computer glitch. The IRS stonewalling must end. The American people deserve the truth. And as we continue to pursue our federal lawsuit, it's clear that a special prosecutor must be appointed to get to the bottom of this troubling scandal. Add your name now to a new ACLJ petition. Call 1-877-989-2255 or add your name online, aclj.org.